So good morning, everybody. Let's speak about these famous registers of beneficial owners. I will concentrate, I will focus on this tool and I will not speak about the identification, generally speaking, of ultimate beneficial owners. And I have found deliberately a provocative title for my presentation, whether registers are a chimera or a reality. In Luxembourg, we don't have any clue from a practical point of view on how this will be implemented, because the bill is still not lodged with the Parliament in Luxembourg. So this, at the beginning, this registers are an idea that was found not by the EU Commission, because when we look at the proposal of the fourth AML directive, there was no provision about these registers, because the FATF never mentioned it in its recommendations. That was proposed actually by the Parliament in Brussels, and there were discussions that led to an adoption of these registers, so Article 30 and 31 in the fourth AML directive. And 1 year after the adoption of the fourth AML directive, the EU Commission came back to these registers and tried to expedite the process of adoption of these registers, and wanted to expedite the interconnection of these registers within or across Europe. Member states were supposed to adopt these registers and connect their registers by the beginning of this year, which had been impossible, but nevertheless they wanted to push member states to implement these registers. In October 2016, FATF, for the first time, mentioned these registers and talked about a tool, among others. That wasn't the key element of the identification of beneficial owners, but it refers to a tool only. In December of last year, there was a compromise of the Council position, because we had some discussions between Commission, Parliament, and Council of Europe about these registers, and that was blocking problems within these discussions. Thereafter, we had the opinion of the European Data Protection Supervisor. This opinion is available to us, and we may read that there must be a balance between the need of transparency to seek, for instance, terrorist financiers, and the need of the privacy. If the privacy is sought or is fought for tax reasons, there isn't a balance anymore, according to the supervisor. So we may go further to seek transparency, but not for tax reasons. Roughly, this is his conclusions. When Luxembourg lodged its bill to implement the fourth AML directive, there was no provision about these registers. So in April of this year, we could try to look for provisions regarding these registers. We couldn't find anything. And we know that unofficially, we are still drafting this bill regarding the two kinds of registers, the one regarding companies and another one regarding trust and foundations. So every day I'm trying to check whether bills are lodged or not, and this is still not the case. So we'll have to wait a few more. So this idea raises many questions, not only from a practical point of view, but there are some, let's say, fundamental rights which may be attacked. So first question, who will provide data in the registers? The idea at the beginning is quite simple. Companies have to know themselves. So they should know their beneficial owners. And is it easy, that easy? No, not at all. Without making jokes, for instance, for Société Anonyme, anonymous companies, if we may translate this, companies which are public limited companies that don't know even their shareholders. Maybe once a year, when we have the approval of the accounts, when there is a general meeting, maybe we will meet some shareholders of this Société Anonyme. But the day after, shareholders may change. So a company is not in a position to know its shareholders. So this is not about registers of shareholders, but for instance, for shares, not registered shares, but the other kind of shares, they have to know beyond the shareholders, they have to know the beneficial owners behind a shareholders. So who will hold the registers? We think that the registry of trade and companies will hold this kind of registers. It's not a bad idea to have the same kind of information in the same premises. Which kind of data will be registered? We know that there will be the name of the beneficial owner. There will be the date and date of birth and the country of residence of this beneficial owner. So not necessarily for companies and trusts. This will be for companies only. Regarding trusts and or foundations, we will have the identity of and the identity only from the identity of the settlor, the trustee, or the beneficiaries of a trust, but not all the data provided for beneficial owners into companies' ultimate beneficial owners. How will we keep these records? Will we keep historical records of these beneficial owners? Of course, as a shareholder may change every minute, a beneficial owner may change as well every minute, of course. So how will we keep the full list of beneficial owners? And will we keep this for 5 years, for instance, just like we have to keep information about our clients and beneficial owners in our files? We don't know. There is no clue into the directive, and no clue, of course, because there is still no bill in Luxembourg. What would be the sanctions of keeping or giving some false information or wrong information? French legislator found that a sanction, a fine of 7,500 euro would be addressed to any company that provided any wrong information. So this is a fine against a company. So if me, as a lawyer, I may have access to this kind of registers, and if I find that there is a wrong information, or if I don't have the same conclusion than the company who registered an information of somebody, if I have another conclusion about the name of the people involved or qualified as beneficial owners, what would be the consequence? Will I have to inform the registry? Will I have to I don't know what, to file a suspicious transaction report to the FIU? I don't know. Whether we don't know. Everybody may have another conclusion than me about who actually governs a company, who actually owns a company. My view may well be that a husband has the power to vote, but instead of my view, another may see that the wife is the actual ultimate beneficial owner. So everybody may file what he wants about the ultimate beneficial owner of a company. We may give rise to a kind of Wikipedia. Everybody puts in a definition or in a registry what he wants. We don't know how this will be handled by the manager of the registers of beneficial owners. And what would be, is this useful at the end of the day? We don't know, because the information, the data is already in our files, in our KYC files. Me as a lawyer, I keep my file about beneficial owners of a client company, and the notary will have another kind of information, or maybe the same information. The bank will have as well its own information about UBO. So the data is here, the information is existing and may be shared between all professionals involved. So, for instance, when the FIU in Luxembourg needs an information about a UBO in such company for which a suspicious activity report has been filed, the FIU tries to look for onto a website regarding all companies, and it may check that the notary that was the last one to to amend the articles of association, we may find the name of the notary who did this, and simply a phone call to the notary. Please give me your KYC so that I may check, I may find who is the ultimate beneficial owners. So we may share information. This is accessible, currently speaking, this is accessible to FIU or other authorities, and also between professionals, because we can't oppose any professional secret to each other when we deal with one single client, with the same client. So we may exchange information, share information about UBO. Why on earth should we centralize this information onto registers? There's no much explanations given by EU Parliament or EU Commission to explain why there is this need of putting in place registers. And of course, the privacy is, this is a serious problem. The privacy maybe is under attack by these registers. We have two different legislations, European legislation, European directives, which are against each other. Directive about data protection against this directive about transparency through beneficial owners registers. So where is the balance? We still don't know. There is some opinion by this European supervisor, but there is no much explanations in the directives or in the proposals of the directives. We may read, we have checked that data protection is under control, but we don't have the previous work or the previous analysis made by EU Commission or EU Parliament. And I wonder where elsewhere in the world do we have implemented this kind of registers? nowhere in the world. So only Europe, in Europe, this is the sole region in the world which implemented this kind of registers. That wasn't required by FATF. That wasn't even required by the EU Commission at the beginning. That was only found by 50 members of the Parliament in 2014. So what is the idea behind? We will have a competition between United States of America with other financial places like Singapore or Hong Kong, with countries or regions which will not implement this kind of registers. We may expect some information or items. So obliged entities may not exclusively rely on the UBO registers to fulfill their client due diligence. This is written in Article 30 of the 4th AML Directive. We force companies to lodge information, lodge data into registers, but professionals like us may not rely exclusively on this information registered in the registers. So why on earth putting this in place? Because we can't rely on this information. So I don't see the purpose, the specific purpose of putting these registers in place. We know that registers will gather data about any kind of company. So not only private limited companies or civil companies will have to comply with this obligation. Any kind of company will have to comply with this obligation to give information. We know that registers will be interconnected across Europe, so French authorities will have access to the registry held in Luxembourg, and we will expedite this interconnection. We won't wait for next year. Maybe if we can put this in place by the end or within 1 year, this is a will of the EU Commission. We know that this will be accessible by competent authorities. So competent authorities. These are the words of the directive, but competent authorities are prosecutor, for instance, or supervisory authorities, or self-regulatory bodies. We don't know. There is no distinction made by the directive. It only reads competent authorities and FIUs without any restriction. We know that these registers will be accessible by obliged entities to perform their customer due diligence, not for another purpose. This will have to concern one of our clients, not the client of our competitor or a counterparty. So what would be likely to happen? We have these UBO registers of companies, including full data, versus UBO registers of trust or foundations. And this second kind of registers will only mention identity of people relating to this trust. So I said before, settlor, trustee, beneficiaries, protector. So their identity only, not their address or date of birth or etc. UBO registers of companies may be accessed by any person or organization that can demonstrate a legitimate interest. So this would be at least the name, the month and year of birth, the nationality and the country of residence of the beneficial owner, as well as the nature and extent of the beneficial interests held. So this kind of information may be accessed to those third parties, to, for instance, investigation journalists, and they will have access to this kind of information for companies only. And this is quite tricky to spread such information around Europe. For instance, if I have a house in France, which is held by a company, itself owned by a Luxembourg company, and if my house in France is to be given to my children would have to be considered as ultimate beneficial owners of this property. And somewhere in Luxembourg, in the registers, people may have access to the name of my children, to maybe their date of birth, etc., and not the exact address, but at least the country of residence. With my name, it is not that difficult to find where I may live or where I may be. And I don't want to spread this kind of information to any person pretending having a legitimate interest to know that. So this is tricky to find a balance between my need of privacy and the need of supposedly journalists to find information. And if behind these journalists we have tax administrations, we don't know. So this will be quite tricky. So UBO registers of trust or foundations will only be accessed by competent authorities, FIUs, and obliged entities. For this kind of registers, these so-called persons presenting or pretending to have a legitimate interest won't have access, according to the current forced AML directive. They won't have access to these kind of registers. We may hope that in Luxembourg we will implement or put in place a special commission to assess the legitimacy of the request made by third parties. And this is to be put in place because, and at least maybe among these, the members of this commission, a judge who will be in better position to assess this need of transparency, but we still don't know. There is no clue about what the government will propose in its bill, but hopefully there will be this kind of commission. There is we know that likely Luxembourg will adopt an exceptional exemption where, but this is regarding UBO registers of companies, exemption to provide information, to file data where there is a risk of kidnapping or where a UBO is a minor of age. I'm thinking about citizens in Brazil or in Mexico who always put in place some BVI companies or other Panamanian companies to hide their wealth. For instance, a yacht or even a house, just because they don't want to be kidnapped or anything or threatened by any mafia or any bad people. And this is perfectly legitimate to hide its own privacy behind companies. There is no need to launder money or hide anything wrong, but there is only a need to hide itself. And why should we judge these people? Why should we try to see behind the wall? We don't know exactly what is the purpose. If I'm thinking about the proposal that was made in July 2016 by the EU Commission, we had an explanation. Okay, we have these terrorist acts in Paris and Brussels, and a few sentences after, but we had this Panama Papers story, so we should speed up the process of adopting this kind of registers. So if I read correctly the idea, will we find some terrorist financiers in the registers? I don't think that these kind of people will be afraid of being listed in this kind of registers. when they are ready to finance some terrorist acts, I think they are ready to be listed in this kind of registry. So I don't see the real purpose of these registries for an information that already exists, that may be shared about between professionals and competent authorities. So I don't see the real purpose. So all that was said, of course, was my own opinions. I don't speak on behalf of anybody in Luxembourg, especially on behalf of the authorities. But this is to be discussed. This is to be shared. This criticism about towards these registers, because there is a lack of explanations. There is a lack of discussion toward these registries. Will open our doors, which will open our windows to anybody which will be interested, which will need transparency. On behalf of what, we don't know. So sorry for all this criticism, but after the presentation made by by the previous speaker, but so let's start the discussion. And what are your feelings about these registers?